While conflict is inevitable, the efficient and fair resolution of legal disputes is not. Too often, relationships are irreparably damaged, and parties needlessly spend vast sums on the litigation process. Hello, my name is Robert Mnookin. Together with colleagues, first at the Stanford Center on Conflict and Negotiation, and now at the Program on Negotiation at the Harvard Law School, I have studied the barriers, strategic, psychological, and institutional, that so often stand in the way of the resolution of conflict. I've been especially interested in how mediators can help parties overcome these barriers and successfully resolve their disputes. During the next hour, you will observe Gary Friedman, an experienced mediator, demonstrate how he works from a particular model of mediation that he, Jack Himmelstein, and I have developed in our work together as teachers and practitioners over a number of years. It's useful at the outset to locate this model in the broader context of the world of mediation. While there is general agreement among practitioners and scholars that a mediator's role is to facilitate negotiation, and that as a mediator, a neutral must lack the power to impose a resolution, there are a number of competing models of mediation. First, this model emphasizes that mediation should be a voluntary, non-coercive process, where the parties are ultimately responsible for whether and how the conflict is resolved. Throughout this mediation, you should observe the various ways Gary makes it clear to the parties that it is their responsibility, not the mediators alone, to search for a resolution. As a corollary, Gary's stance towards the parties is facilitative, not manipulative or coercive. Second, this model assumes that in legal disputes, the law is inescapably relevant, but the law need not be the exclusive or even primary basis for a mediated resolution. Parties bargain in the law's shadow because one or both parties can pursue the alternative of litigation. If the dispute is not resolved by agreement, a judge or arbitrator can impose a resolution. How can one compare options generated by the mediation process with this litigation alternative, absent some understanding of the opportunities and risks of continued litigation? On the other hand, a great advantage of mediation is that parties can often shape a resolution that reflects their economic and personal interests and needs far better than an adjudicated outcome. Third, this model assumes that by working together with the parties and their counsel and avoiding separate meetings and shuttle diplomacy, where the mediator alone has information from both sides, mediation offers each party the best opportunity to deepen their own understanding of both their own perspective and interests and those of the other side. Embracing conflict is often the best opportunity to create value.
Thanks for coming here this morning to meet with me, to see whether mediation is going to be the way.
This mediation brings together Jackie, who until recently served as Artistic Director for Dance Innovation, or DI, and Mike, DI's Executive Director and Chairman of the Board, who dismissed Jackie midway through her 3-year contract. DI is a well-known modern dance company whose mission is to support the work of new choreographers. Jackie's job was to guide that mission. In her first year, Jackie created 2 of her own pieces, which were well received. She was nearing completion on a 3rd major work, Ensemble, which was to be the centerpiece of DI's upcoming season, when that piece became instead the focal point of a conflict between Mike and Jackie that culminated in her dismissal. Jackie consulted Conrad, a lawyer who represents artists. Conrad sent a letter to DI's lawyer, Joan, saying that since Ensemble was not yet complete, it belonged to the artist and that he would go to court to prevent the dance from being performed if DI planned to complete and put on the work without Jackie.
Speaking for Jackie, she has some interest in doing this. The truth of the matter, though, is she's been taken advantage of, and she's come to me in a bind. She can do what most artists would do, which is sort of go quietly, or she can stick up for herself, and she can say, no, it's wrong. You can't just use my services and then steal my work and take advantage of me that way, counting on the fact that it's the ethos in this profession to keep quiet. That kind of extortion, frankly, is not the kind of thing that she's going to settle for.
So if I understand you correctly, what you're saying is that she comes here with some intention to see if she can work things out, and that she has a kind of natural inclination and has in the past found herself kind of going along with things, and that represents a concern that you have in terms of this process.
The fact of the matter is, Jackie has done anything but sort of go along with things. We've had trouble with her fiscal responsibility. We've had trouble with some of her artistic work. There have been some works she's created that have been successful for the company, but there have been other works that have not. And I think it's very important that Jackie understand that if we do resolve this one way or the other, and that one way happens to be in court, it will be very expensive. Your reputation will be at issue. The company will not hold back if that's the way we choose to go. The company, at the same time, appreciates that there is some uncertainty in the judicial process.
So you come here, Joan, with some concerns as well. I hear a desire on your part to see if you can work things out on some basis that will not require having to litigate. You're also prepared to litigate if it's necessary. Is that
I
correct?
think that's correct.
The goal here really is to see if I can help you work together to make decisions based on what's important to you that will leave both sides in a position that's better off than you would have been if you were to proceed with litigation. I wouldn't act as the judge. The idea is that really the two of you are the judges, and that if we come to something that you both feel is right, then we've done our job, and if we don't, then you're hopefully no worse off other than the time and money that you've invested in this process.
I'm certainly not trying to tell you your business, but I don't understand how the five of us sitting in a room with Conrad making really rather inflammatory comments is going to further any understanding. The company acted in good faith in the discharge of what we thought were our obligations.
Well, that's up for dispute.
It may be up for dispute. I'd wonder whether it wouldn't be more helpful if we met separately with you, and if you want to convey our views or convey their views, fine, but I really don't see that this face-to-face meeting is going to advance anything.
I want to hear what you're going to say. And I want to hear what you're going to say, because already she said something that isn't true, which is that some of my works are not well received. The works that were not well received were the works by the newer choreographers. And I kept telling you, it's hard to find good young choreographers whose works are going to be up to the level that I thought this company was interested in.
Well, I'm hearing two different things here. One is, it sounds like you were upset by the way Conrad characterized the actions of the company.
I don't see how I could have been other than upset, and I can't understand how he could have thought other than what he was saying was upsetting.
Right. I do think that that's a normal part of the mediation process. The question is, given that upset and the fact that you have your differences, whether or not meeting in the same room is going to be a productive way of dealing with those differences. And I'm hearing from you that you want to be here to know not just what's said by your side, but what's said by the other. And I guess
Gary started the mediation seeking to assure that Mike and Jackie become full, active, and responsible participants in the process. In the approach to mediation we have been developing through the Center for Mediation in Law, we believe that it is the parties, rather than the professionals, who ultimately have the best understanding of what underlies their dispute, although the intensity of the conflict can obscure their view. It is the parties' conflict, and they hold the key to reaching a solution that best serves them both. Gary is also seeking actively to understand each participant and demonstrate that he has understood them, what we call completing the loop of understanding, or simply looping. Done correctly, it helps bring clarity about what is being said and meant. But it also brings the power of understanding to bear on the conflict. For us, increasing understanding and responsibility while reducing coercion and pressure is at the core of mediation.
From a secure job, a better paying job, and now halfway through her contract, put her out, no more income coming in, and on top of that, they're trying to steal her works. Now they're going to have to
Nobody's
either
trying to
make,
steal her
they're either
works.
going to have to
Are we
make
trying to reach an agreement, or are we
completely
posturing?
enormous changes in their position, or this isn't going to go anywhere. And the only way they're going to have to they're only going to make those changes is if they understand what they're up against and what they've done.
We
They're up
understand
against,
what we're up
essentially
against.
what we have here is a company run by dilettantes that has been run into the ground by this man. They will be exposing themselves in court and in the public to the seamy side of what they've done. Because that's the only thing my client now is left. She has nothing to lose. They've taken her services, they've taken her work, and they're trying to take her reputation.
It's great that you're putting on this fantastic show for your client, Conrad, but you're living in a fantasy world in terms of the law. I mean, the reality is she signed a contract that clearly states that the works that are produced during her employment with my client belong to my client. That contract law is clear, as is the work for hire law that's out there.
The fact that you're prepared and that you're prepared to litigate, I think, is a strength of the mediation process, because it will really direct us toward trying to find solutions that don't leave either of you worse off than you would have been if you went to court. In order to do that, we're going to look not just at the legal reality here, and that there are other things that are of significance to both the company and to you that are maybe of a more personal nature and certainly are of a business nature.
In the mediation of any dispute where there is the potential for litigation, it is useful to think about two different sorts of conversations that can take place. Some mediators try to focus exclusively on the law and attempt to settle cases simply by helping the parties have sufficiently convergent expectations of what is likely to happen in court. Other mediators try to avoid the law altogether and instead search for agreements that build exclusively on the parties' interests. As you will see in the scenes to follow, this mediation encompasses both kinds of conversations and accepts that there may often be a tension between them.
What you referred to as the more personal dimension or personal issues are probably things that wouldn't really get heard in court. And I feel like I have a more authentic and present voice in a situation like this.
And how about you?
I'd have to be frank with you that I go into this with some, I won't say reservation, I'll commit to in good faith try it, but I've got to continually be testing what makes sense for this dance company and what makes sense for me personally.
Are you willing to say what the reservation is about you personally?
Look, I work as the chairman of the board of this dance company because of my personal commitment to the arts, because of a commitment to the arts that my family has had for some time. This is not my livelihood. I've made some sacrifices, and it seems to me at this point that this is proof that no good deed goes unpunished. If we can have a rational discussion and try and work things out, that's fine. If we can't and meeting separately would be more productive, I'd like to try that.
Since ultimately it's going to be the two of you, Mike and Jackie, that are going to have to make ultimately the decision about whether or not we create a solution here that you're willing to get behind. I want the two of you to have as full an understanding of all the dimensions of the problem as we can possibly provide for you. And my sense is that you'll have that if you can be present for all the discussions and we can make those discussions productive.
These are the first agreements the participants make together, and, if reached in a genuine way, can help maximize the parties' shared understanding of, commitment to, and responsibility for the mediation.
I don't want this process to be used in a way that would allow Conrad to get information he either otherwise wouldn't be entitled to in court, or just to, harass my client.
And your view about this?
For us to be able to decide here and now what makes sense to do in a mediation, we'll have to be able to evaluate the strength of your claims. And to do that, we'd need to see some documentation.
I want you to have everything that's legally relevant. And I think you each need to be sure the other side has everything that's legally relevant. Why? Because if we're going to be in a position where we're going to really be asking you to assess what the legal risks and outcomes would likely be, we're not going to be able to do that job right without having that. I guess I just want to be sure that in that mix that you consider the risk of not being open. And in the litigation atmosphere, the less information you give, the better off you are. In this situation, in many ways, the more information you give, the fuller basis we have to see what underlies this dispute. Are you ready for each of you to kind of describe your legal position so that your clients and I can understand those?
Let's understand that the basics here are the creator of the work owns the work. The exceptions under the Copyright Act are for works for hire. A work for hire can only exist in its completed state. The Act doesn't contemplate unfinished work. And whereas here you have a work that was never fully completed, you can't claim ownership to that.
Jackie substantially completed that work, or whatever work was completed is a work that which she prepared during the course of her employment with the company. She used company dancers, et cetera, and it is the company's position that that also clearly belongs to the company.
A critical role the mediator can play is to help the parties deepen their understanding of the risks and uncertainties of the litigation process.
Just for the moment, assume the unthinkable has happened. You've gone to court and you've lost the case. And now you have to explain to your clients all the reasons why that could have happened. And if you're willing, I'd like to have each of you kind of flesh out the risk part of this so that your clients have an appreciation of that. Is that something you'd be willing to do?
One reason is that judges aren't always right. And it may be that the judge doesn't quite see it our way.
While lawyers are often initially reluctant to acknowledge any weaknesses in their case, with the mediator's help, they can take this task seriously.
And it is possible that a judge would want to see this in the narrowest possible legal terms without regard to the equities. That can happen.
A judge may be persuaded to, in a sense, put the law aside, notwithstanding that we have the better legal argument, and feel that he wanted to have a certain result come out, and that result would be to support the artist in this instance.
An assessment of litigation also requires making sure that the parties understand the practical consequences of going to court.
I think it's important, as you and I have discussed, to know that the bringing of the case was something that was important to you, and that even if they win and we, quote, lose, you will have helped your reputation in the community as you go forward by showing your pride in your work and your pride in the integrity of dancers and choreographers in the community by trying to stand up for the control that you believe choreographers ought to exercise over their work.
You've given her a completely false sense of what's going to happen at the end of the day.
I'm not worried if the court says this piece cannot be put on. That's exactly what I want to have happen if I don't finish the piece. I don't want to see that piece performed in its present state. It is not completed. And I certainly don't want to see it performed with somebody else's ending on it.
So it's really a high priority for you to know that that piece would never see the light of day without your being able to
Right.
contribute to the finishing of it.
Right.
And I think exactly the problem we have is that Jackie is much more concerned about her piece, completed the way she wants it, when she wants it, than she is with acting as the artistic director of this company or taking any concern to the needs of this company.
And it's interesting to me because what I see happening here is you got somebody from the business community who is trying to transpose what may be business norms into an artistic setting. I don't think Mike understands that what he is essentially setting in motion is a public display of a company in turmoil. Why would other choreographers or dancers or artistic directors want to be associated with you? Why would funders want to give money to you? Why would potential board members want to be associated with what will be ultimately an unsuccessful and unpleasant venture?
That the company is in turmoil is something that we've been aware of, and in fact the dance community has been aware of. We had hoped that Jackie's coming as the artistic director would in fact reduce that turmoil. In fact, she has contributed to our turmoil. She has, in my view, wasted the assets of the company. I am concerned about the presentation of works of a variety of choreographers. It was for that reason that we retained her. We were not retaining her to be a funding source for the development of her piece, however marvelous it may be.
But I think your ignorance of the artistic norms in this community are going to bring your company down, pure and simple.
And if the company is brought down, it will be your client and to some extent your attitude which will have contributed very significantly to it. And I don't think that that will stand your client in good stead in the dance community.
I didn't fire my client, you did. I didn't seek ownership of her rights, you
I
did.
would
And
have
think
been
that's what's gonna
derelict in
hurt
my
you.
duty had I not fired your client.
I'd like to make an observation, because I can see how upset you each are with what the other's saying. And while there are some advantages to both sides in terms of being able to proceed in court if you win, there are also some costs here to both sides, no matter who wins. If you do go to court, one of the consequences is clearly going to be that a division between the two of you will be escalated even further than it is already, and that is going to have some consequences for both sides that I think you just need to take into account.
That's why we're here.
Having explored the legal reality, Gary now turns to the second conversation, gaining understanding about the business and personal concerns at stake. Where the lawyers were foreground in the first conversation, here the parties are the experts. Indeed, you will see that Gary has actually invited Mike and Jackie to change places with their lawyers so that they are sitting nearer to him and he can give them his full attention. His goal is to support each of them in articulating what they view as important, not so much in terms of their positions, but rather what underlies their dispute at a deeper level. As we return to this next stage, Gary seeks to be sure that there is agreement about this task and that the parties are motivated to assert what they really care about.
Does this make sense to you to do?
Yes, I mean, I think this is the part that's frankly beginning to make the most sense.
Mm-hmm. How so?
In the sense that if we're going to have any kind of resolution of the conflict without litigation, the issue is not the lawyers going to war, but Jackie and me, Jackie and the company, finding some way to work together, some basis for settlement.
Mm-hmm.
And I don't see that happening except the two of us talking.
From my perspective, the more understanding you each have of what is important to you and to each other can really be critical to our finding a kind of solution that is going to be more individually satisfying than a kind of more objective or cookie-cutter solution. And Jackie, where are you with this now? Does this still make sense to you to proceed?
Yeah. I started out with a very different feeling than what happened along the line. And one of my interests is trying to figure out how that happened.
Would you prefer to go first?
I don't think it matters to me.
How about you, Mike?
Okay. Dance Innovations is a smaller dance company here in the city. Formed a number of years ago, and kind of our first choreographer or artistic director was Peter George. We were really
Mike then recounts the bind he was in as more of the company's time and resources went into the production of Ensemble, to the neglect, as he saw it, of the company's mission to support new choreographers. Much has been said and written about mediator neutrality, the importance of maintaining objectivity and not being on one side or the other. Our approach to mediation seeks to develop a sense of a subjective, positive neutrality, where the mediator works hard to be on both sides. Having sought to gain an empathic understanding of what is most significant to Mike, the challenge for Gary is to be fully there for Jackie, whose view is very different.
On top of this, Mike and the board asked me to do something that I did not understand to be in the original agreement, which was to go out and do fundraising. You know, I understood the concerns about saving money, and I already knew that there were tensions between Mike and me. The thing that gets me is, you know, that Mike is turning this into that I just wanted to promote myself.
That really cuts to the quick here for you is to feel accused by Mike and or the board of not wanting to support the development of other choreographers, because that was, and sounds like still is, so close to your heart.
Right. The bottom line, to use a business term, in dance or any other art, is the quality of the work. If you don't have the quality of the work, the funding, the audience is not going to last.
If there isn't a company, if we can't preserve the financial viability of the company, there will be no dance. You know, Jackie has, to some extent, turned the matter around. Part of the difference between the artistic director and a choreographer is the ability to bring that added dimension, the ability to balance the search for other choreographers, the need for funds, and the artistic vision. And, you know, I'm truly sorry that Jackie feels so emotionally wounded. But the fact is that whatever her inner feelings, her performance was not responsive to the mandate that we have.
It was because Jackie was so working so hard on Ensemble was the very problem that you felt was taking away from the rest of the mandate that was so upsetting to you and sounds like also to the board.
Yes, I mean, upsetting may be the wrong term because it puts it on the wrong level.
I mean, the reason I said upsetting is you seem upset when you just said all that.
Then maybe upsetting.
Mm-hmm. I mean, if it doesn't fit, tell me, but it sounds like this is hard for you too.
Well, of course it's hard. I mean, I recognize it's hard for Jackie. It's hard for the members of the board. It's hard for me. Were this not hard, we wouldn't be here. Mm-hmm. But we are here, and we do have a dispute.
Right. Yeah, we are here. There is a dispute. There are differences between you, and I find it helpful you're acknowledging the level on which it's personally hard for you too.
By inviting Mike to express how the dispute impacts him personally, Gary seeks to encourage authentic communication about all aspects of the experience of the conflict that have meaning for the parties: business and personal, financial and relational, thoughts and feelings. Having understood both Mike and Jackie, Gary now has what we call the mediative perspective, where he can hold both views as valid without having to choose between them. Jackie and Mike have deepened their understanding of their own views of what is important for them underlying the dispute, and likely feel understood and supported by the mediator. There is now the opportunity to see if the parties are motivated to try to understand each other. When parties are willing, this next step makes it possible that mediation not only supports the autonomy of each party, but also honors their connection.
I mean, you've both done a really terrific job of expressing your different points of view. And as I sit here listening to both sides, it doesn't feel to me at all as if either side, what either of you saying, cancels out the other. And I guess what I wonder whether would be useful to you, for you each to know how, to what extent you're understood by the other